success. Okay, so I understand today is the first day of spring, and I am excited to see everybody joining us here, ready for a bit of spring cleaning for harmful proposals and planting seeds and ideas for humane immigration policies. My name is Ellen Miller. I use she, her pronouns, and I am the pro bono manager at the National Immigrant Justice Center. Today, we are here to learn more about and take action against Biden's proposed asylum ban. I'll get us started with a few housekeeping tips today. The session will be in two parts. During the first part, where my colleagues will explain the proposed rule and potential impacts, all participants will be on mute. We will be recording the presentation and it will be posted on our website soon. During the presentation, we welcome questions via the chat function. Participants are welcome to stay on video if you're comfortable, or you can take yourself off, whatever you feel is best. The second part of today's session is a live workshop to prepare your comments with NIJC staff and colleagues. We will not record this section. Staying for the workshop is optional, but encouraged if it helps us get timely comments submitted. All participants are able to be on video and come off mute during the second part of the session. And finally, while no CLEs are offered for today's session, we will share a QR code at the end of the presentation, and any feedback will help our programs stay strong. Let's see here. I'm going to advance the slides. So if some of you are not familiar with NIJC, welcome. We're excited to have you here. I will briefly share a bit about what we do and how we do it. With 5 offices across the country, a staff of approximately 130, and a wonderful, inspiring pro bono network of more than 2,000 active attorneys and legal volunteers, we are a community that ensures access to justice for immigrants, asylum seekers, and refugees. Blending individual client advocacy with broad-based systemic change, we use an integral service model that incorporates federal impact litigation, education and advocacy, alongside direct legal services for more than 10,000 non-citizens every year. You'll hear about some of the work in today's presentation. Because, as always, we have lots to do, I'd like to introduce our presenters today. Azadeh Irfani, a senior policy analyst, and Isabella Olm, a policy and litigation intern, have been working diligently to parse through the proposal and make today's presentation and template easily accessible and effective. Julie Rich diligently and compassionately represents asylum-seeking clients and provides technical assistance to pro bono attorneys in their representation of clients. Today, this team will share about the proposed rule, the impact it could have on your clients, and guide you through crafting your own comments. As many of you know, and why you are here today, access to counsel can save lives. Thank you for joining us as we continue to advocate for a just immigration system. I'm now going to turn it over to Azadeh. Thank you.
Thanks so much, Ellen, and thank you everybody for carving out time on your Monday for this webinar and tackling this complicated rule. I'm gonna just do a little bit of level setting at first. I'm sure many of you are experts or very knowledgeable, at least with respect to asylum, but this background may still come in handy with respect to some of the problems that we face with this rule. So the way in which asylum law has been shaped is largely in response or as a reaction to the Nazi genocide and the Holocaust in World War II. And one of the probably less familiar byproducts of this, of World War II, was the fact that many nations were actually turning away people who were fleeing these harms and who were fleeing genocide, including the United States, who has returned nearly 1,000 Jewish Europeans back to the genocidal harm that they were fleeing at a time where they were desperately seeking protection. So fast forward to 1951, the international community comes together and has a reckoning with the fact that it is time to have a uniform scheme around the world in order to ensure that this never happens again. And that is the crux behind the Refugee Convention. The United States plays a leadership role in terms of shaping that language, and by 1967 joins it via the Refugee Protocol that it accedes to. And then finally in 1980, these international treaties and basically the scheme of international protection for asylum seekers is incorporated and codified into US domestic law. In 1980, the United States passes the Refugee Act, which previously passed unanimously through the Senate in 1979. And all of this gets codified in Title 8 of the US Code. Title 8 is important because we will be talking about Title 42, which is basically a public health statute that has been manipulated to make its way into immigration processing. So we'll be talking about that in just a moment. So at the next slide, we'll be talking about just the basic definition of what it means to flee. And that definition is housed in, again, Title 8 of the US Code, the section 1158. And reading it really briefly, it says that any person who is physically present in the United States and who arrives in the United States, whether or not at a designated port of arrival, and including people who are interdicted at sea, irrespective of their status, may apply for asylum under section 1225 of this title. Really important to this definition is almost more what it leaves out than what it leaves in. So there is no requirement here to have a passport. There's no requirement here to have status. There is no requirement to enter at a port of entry. All of these things would be basically added onto the statute or imposed on the statute because it was intentionally meant to be as broad as feasible so that the harms that we discussed prior are never repeated again, where people are sent back to their persecutors. So at the next slide, we'll be talking about a slew of Biden border policies that have been rolled out over the past couple of months, as well as the past couple of years. First and foremost, there is a set of parole programs that this administration has been rolling out in order to diminish the number of people who are apprehended at the US border. And these parole programs are sort of made up to be a replacement for asylum, but in so many ways they are not. First of all, they're temporary permission to enter the United States. They're not, you still have to apply for asylum when you get here, and there's a lot of restrictions in terms of who can apply for these parole programs. You have to be able to afford plane travel. You have to be able to secure a passport, including from the country that may be persecuting you, right? You may need to turn around and ask them for a passport. And there's also, and that's a really important thing, you need to have someone who can financially sponsor you. So basically ensure that they will cover your expenses in the United States so that you don't become a public charge, quote unquote. There's a cap on this, and 4 different nationalities are competing for a 30,000 person cap per month. Although the number of people who have been able to avail themselves of this, who have, again, the time to wait, the means to secure a passport, and the connections to a US sponsor, those numbers are, as you could expect, not as high as one would think. So it's in many ways not a replacement for access to asylum at the border. And at the same time as this administration has rolled out Title 40, these parole programs, it has also expanded Title 42 to apply to these nationalities, even though, and this is the part that is always really hard to explain because it makes no sense. Back in April of 2021, they actually tried to end this policy. They faced litigation and then turned around and expanded it by striking an agreement with Mexico to accept Venezuelans, Nicaraguans, Haitians, and Cubans who could not previously be returned to their countries of origin so that they could be expelled into Mexico. Title 42 does not include any type of screening for asylum. So that means that it is routinely a vehicle for returning people to harm and essentially what international law calls refoulement or refoulement. So this policy is supposed to end come May 11th because a public health emergency is supposed to lapse by then. And why that's important because of where we are today is that once this policy is ending, this administration is trying to basically substitute the mass expulsion scheme that we have with Title 42 with this asylum ban. So more on that in a moment. The administration has also decided to expand expedited removal, and by that, they mean essentially conducting rapid fear screenings at CBP jails, something that used to happen under the Trump administration and caused significant devastation for people who were subjected to that. So basically forcing people to go through within hours, within days, or weeks of the trauma that they fled, the violence that they fled, having to go through these screenings that will really have life or death consequences for them, right? Because if they fail, they are returned back and they're barred under expedited removal for 5 years from returning back. And they can no longer seek asylum either. So that's another feature of this. And I'll add a footnote. I'm sure many of you have seen the news about family detention potentially also being back on the table. So all of these are providing really a really cruel menu of options for this administration to subject people to some of the worst conditions possible in order for them to, you know, be doomed to fail these screenings and then be returned to their countries. So all of this leads also to the asylum ban that we have today. That ban is proposed, and it will actually you'll have a 30-day, there's a 30-day comment period that ends next Monday at 11:59 p.m. Eastern. And essentially what you see on the screen is what this ban consists in. So if I travel through any other country than my country of origin in order to reach the United States, I can be presumptively banned. If I also have traveled to the US border without a valid visa, visas to the United States can be extremely hard to obtain, remember. And if I don't have a passport from my country of persecution, I can also be banned. So those two circumstances together are combining two things that used to be called the transit ban and the entry ban under the prior administration. And the Biden administration is basically mixing them together so that anyone who meets those two features could be subject to a presumption that they're not eligible for asylum. Now, there is one catch, which is that if I'm able to secure an appointment through the CBP One app, then there's basically an off-ramp from this harmful presumption. But as we'll discuss later, those appointments and this app are really treacherous and have been the source of a lot of problems for people who have been trying to use them. So not a solution in any means, and have been complicating things even further and keeping people waiting in danger. So next, just discussing a little bit more what this rule is actually doing. I do want to mention that, you know, this rule is defining itself as circumventing lawful pathways, which is a really, really misleading way to characterize what they are doing, because they, you know, that broad definition that we talked about in the US Code is making it asylum accessible to anyone, regardless of their mode of entry or where they travel. And nevertheless, this administration is trying to say that only people, you know, who are able to use an app or who are able to travel through these parole programs that they have set up and that are only available to certain nationalities are availing themselves of quote unquote lawful pathways. So be very cautious when you see that. It is absolutely lawful to seek asylum at the US border. And that should not, this administration should not be forgetting that, or you know, messaging in any different fashion, but that is unfortunately how this rule is set up. This rule has the bars that you can see in the center that we've already talked through. Importantly, if, you know, if I'm subject to this presumption that the Biden administration is setting up, then I also I'm facing a higher burden in order to get protection. So, and this is very similar to the Trump administration as well. So withholding of removal or deferral of removal under the Convention Against Torture as well can be accessible to me, but those have much, much higher burdens of proof, and not only at the fear interview, but at the merit stage as well. And so essentially, this is a thinly veiled attempt to return people to harm, knowing that folks who are unable to meet this higher threshold are going to be, are going to fail and are going to be returned. Another thing to note is that people with withholding or protection under the Convention Against Torture cannot petition for families. So spouse, children, those folks are required to try on their own to seek protection in the US. Even if they're threatened, even if they're in danger back in home country, I can't petition for them if I have withholding or CAT protection. Similarly, I can't travel. I can't even go to a third country in order to see my family if I get that kind of relief. And there is no path to citizenship, so no opportunity for me to stabilize my status. And in fact, the government may try to remove me to a third country every year or every other year, right? So it's very much a fragile, and to say that it's incomplete or insufficient is an understatement with respect to what that kind of protection means. Now, there's some people who are able to basically, again, have some form of off-ramp from this, this presumption, this presumptive bar to asylum. The most important category is that unaccompanied children are not going to be subject to this rule. They're already not subject to expedited removal, so that is you know, that's sort of a low-hanging fruit in terms of what this administration could have permitted. But additionally, if I'm subject to this presumption, but I can prove that I have one of the 3 bullet points on your far right that you see, that basically I was a victim of severe trafficking, or I faced an acute medical emergency or an extreme danger or threat, I can prove that I met an exceptionally compelling circumstance There's also some provisions about if, you know, I can prove that the CBP1 app was malfunctioning for me. But again, all of those things put the burden on me to prove those things in order to have access to something that is already, you know, a right under domestic and international law. On the next slide, we'll be actually talking a little bit more concretely about this, and I'll turn it over to my colleague Julie to talk through about her client and how he would have been subject to this rule.
Hi. How's it? Are you able to hear me?
Yep.
Great. First of all, I want to thank each of you for taking the time to attend this incredibly important workshop. My name is Julie Rich. I use she, her pronouns. I am a staff attorney with the National Immigrant Justice Center. Prior to that, I worked in the state court system for over 20 years doing administrative and regulatory work. And on both counts, I can share with you just how critically important your time is here today and the comments that you will submit. Many of you probably have your own stories, anecdotes about individuals who have been aided by the asylum process who might not have that opportunity were these proposed rules to have been in effect. And there's any number of examples we could provide you, but today I decided I would just share one. And I share it partly because it's fairly recent and partly because I think it's a compelling example of the intrinsic unfairness of these proposed rules. The photo on your screen is a picture of me shortly after our client Komlan from West Africa received asylum. I have his permission to use the photo, just so you're aware. Komlan is a really extraordinary young man. He is from Western Africa. He was raised in a very large family of very, very modest means, good student, worked hard, went to school, started university, and became certified as a civil engineer. In his early 20s, he became interested in politics. He cares deeply about democracy. He was troubled that his own country had had the same family in power for over 20 years. He was troubled that people from his country who had fled a previous generation wanted to return and were facing discrimination. And so he joined a political opposition party and started attending protests. So he wasn't a high-level political activist. He was one of those folks on the ground chanting and leading the group. And ironically, they were advocating safety for returning immigrants, and also executive term limits. They were trying to get the president to agree to executive term limits so that they could not spend their entire life in power. On his third protest, a police officer followed him home. When he got home from the protest, he was sitting in the living room talking to his mom about how the protest had gone. And the police descended on the home. They seized him. They threatened his mother. They dragged him out of the house. They took him to a nearby police station. And they demanded that he tell them the names of other protesters. And Komlan was unwilling to do that. He did not want to put anyone out at risk, so he stayed silent. And so they beat him. They kicked him. They threw him in jail. And he spent the next couple of weeks subject to repeated interrogation and torture. He was forced to stare into the sun for long periods of time. He was forced to stand holding heavy, heavy cement blocks, and if he dropped them, they would beat him. They had a barrel with a rough, ragged edge full of oily water, and they would shove his head into the barrel, and he thought he would drown. After several weeks of this and almost no food or water, he learned he was going to be transferred to a civil prison. And he knew that no one survived that prison. But that wasn't the end of Komlan's story. In kind of an amazing twist of fate, that very night, someone who worked at the jail let him sneak out, helped him sneak out. Turns out that individual had known his father, felt badly about what was happening. So suddenly he found himself released in the middle of the night in really quite dire physical pain, and knew he couldn't go home, didn't want to put mom at risk. So he went to a friend's house, and his friend rose to the occasion, found him a place to rest and hide while he made arrangements to get Komlan out of the country. And while the US was always their goal, to get him to Brazil. And it's a little questionable whether the visa he obtained for his friend was legal or not. No one was in a position to ask questions at that time. He found himself on a plane to Brazil, and he arrived with almost no money and a cell phone. He made his way to a homeless shelter. And I think it was literally that night or the next day, someone stole his cell phone. So he had absolutely no access to contact his family back home. Certainly he would have had no way with the language. He stayed at the shelter for a number of weeks, and then their policy was they had to kick you out. And so that's literally what they did. They put his stuff on the curb and changed the access code, and he was homeless in the streets of Brazil. Nobody told him that there was a mechanism for asylum. He tried to get work. He would go up to construction sites and ask if they needed a hand. Most of the time they told him to get lost because he didn't speak Portuguese. He began to realize that in Brazil, there's extensive discrimination against Africans who have come. Occasionally, he would hear people from his home country, but he was afraid to contact them because he didn't know if they were affiliated with the government. Finally, after a period of time, he kind of gathered the wherewithal to start moving towards the United States. And from Brazil, he literally walked or took buses through all those countries to get to the US border. Again, this is including going through jungles, trying to cross borders, and it also happened to be when COVID had hit. So sometimes the borders were closed and it took a very long time for him to make his way to the United States, where he presented himself at a port of entry and claimed asylum. Fortunately for Komlan, this ban was not in place. He passed a credible fear inquiry, even though it appears that it was conducted in Spanish when he is a French speaker. He somehow was able to communicate his need to them. He made his way to Chicago. The Kovlar Center connected with him. NIJC was able to represent him. And I'm thrilled to say he won asylum. And even DHS acknowledged that this individual, as a political detainee and sufferer of torture, belonged here. But I don't know that this would have happened had this proposed asylum ban been in place. With a stolen cell phone, no money, and not speaking the language, there was no way he could avail himself of accessing some app to make an appointment. There was no way he could apply for asylum in any of the countries that he walked through to get to the United States. I don't know if he would have passed a credible fear inquiry. He's a very soft-spoken young man who does not disclose a lot without asking the right questions. He's modest, he's quiet. He was somebody who was able to withhold disclosing names of people he feared he would put at risk through torture. And what he really wants more than anything is to become an American citizen, join the US military to serve this country, and see his mom again. He hasn't seen his mom since he got hauled out of that home, now almost 2 years ago. But if he were deprived of the opportunity to seek asylum, even if he were granted withholding of removal or cat protection, he couldn't leave the country and he couldn't go visit her anywhere. So this is just one of many, many examples of someone who would be very, very adversely affected by these proposed rules. And so I want to thank each of you for taking the time to meet with us today, taking the time to write a comment, and I appreciate your time very much.
Thank you so much, Julie. I think I'm sure many of us are thinking about Komlan and the incredible journey that he's had, and how important it is that he finally has protection now. If this story is reminding you of the asylum seekers that you have worked with, that is exactly what we were hoping for. Please make a note of that, and we're happy to address any potential connections in terms of your individual comment during the workshop portion of this. But remember, again, Komlan's story is so illustrative of this. Legal pathways are important, but they're just no replacement, right, for actual access at the border. And the fact that this administration is basically having one rule that applies at the US-Mexico border and other rules that apply elsewhere should be a huge source of distress for us, because this asylum system is supposed to be uniform. It's supposed to be egalitarian in the way in which it provides access, regardless of means, regardless of people's access to these quote unquote parole programs or lawful pathways, as they call them. Another important reminder is that the manner of entry is not something that the US government is entitled to punish asylum seekers for. Access at all ports of entries and between ports of entries is guaranteed by law, so long as someone is seeking asylum. And of course, Kamlan's story is very compelling in that respect. People need time, right? There's literally physical and emotional scars that they are bearing, and imposing a fast-paced screening that they are essentially set up to fail is all but certain to return them to the harm that they have fled. And once again, fairness is more important than speed. And unfortunately, this administration keeps sacrificing the former for the latter. And last but not least, these types of transit bans, or the kind of, the fact that this administration is trying to restrict individuals from asylum access if they've traveled through other countries, is disparately going to harm asylum seekers of color, especially Black asylum seekers, like Kamlan, and LGBTQ asylum seekers. So individuals who are unable to avail themselves of protection along the road are likely to show up at the border, and they're likely to get banned under this new rule. So that should be, again, the source of alarm for all of us. And that is basically all we have for you today. And on the next, we're going to turn to this comment and walk you through how important it is to draft your own individual comment. We have a template that we're going to talk through in a moment, and essentially giving you tips about where you can include the stories of your clients and your experience. You're more than welcome to send us questions, and please and make sure to share any feedback that you have with us on the QR code that follows in the next slide. And with that, I think I can turn it over to my colleague Isabella to introduce the template for us.
Great, thank you so much. And thank you, Julie, for sharing Kamlan's story. And again, for all of you for joining today. I'll start with some reminders for how to submit a comment, and then we can review the comment template that we've provided today. So to begin, if you'd like to review the proposed rule before you submit your comment, it's linked in the introduction along with the link to submit your comment. And as Azadeh began to explain, current regulations require that federal agencies give members of the public the opportunity to comment on proposed rules. And these agencies are required to read and consider each comment. However, to trigger this mandatory review, each comment must be unique. For this reason, it's very important to individualize your comment and not only copy and paste from this template. So if you could please personalize your comment as much as you can. Your personal or professional experience working with asylum seekers is valuable, and adding your experience only strengthens your comment. So we've provided some suggestions in areas where you might include your own analysis or anecdotes, and those are highlighted in yellow in the template. And on that note, you can choose to include some or all of the suggested sections, or even create your own new ones. So do not feel bound by the structure of the template as it exists. And further, you do not have to write in your official capacity in order to make an impact. Your training and analysis and just interest in the rule is enough to provide a valuable comment. However, if you can submit on behalf of your firm or organization, highlighting your pro bono practice will strengthen the comment. And as we've mentioned, though we've allocated time for you to write your comment today, please note that all comments are due 1 week from today, March 27th at 11:59 Eastern Time. Great, so if we want to keep moving through the template, we will start with the introduction for each template comment, and it's a brief introduction for your use. This is a place where, if you'd like, you can begin to highlight your own interest in the rule, your experience, and your general concerns about restricting asylum access. Great, and in this next section, we've provided a more general introduction and overview of the rule. As you may know, before the rule was released, hundreds of community organizations and members of Congress have called on the administration to abandon this revival of Trump-era asylum bans. However, the administration has largely ignored these calls, which really just highlights the importance of commenting and really coming strong. And the preamble of the rule focuses on the pressures at the border that have been caused by an increase in numbers of arrivals. However, we know that the administration's response does not need to be increasingly restrictive measures like these. There are humane and practical solutions that are available to this administration, including increased funding and collaboration with organizations that already exist and are supporting asylum seekers on the border and throughout the country. So in this section, you will see some ways that you can counter this idea and again, emphasize the need for an increase in support instead of restrictive measures like these. Further, with your own experience, you could discuss ways that the deck is already stacked against asylum seekers and how factors unrelated to their legal claim could contribute to a denial of relief. And in this next section, we have outlined some objections to this very limited 30-day comment period. The regulations itself provide that typically there should be a minimum of 60 days for a comment period. And as we know in this case, the public was only given 30 days to provide comment. The justification given relies on the anticipation around the end of the Title 42 public health policy that's coming this May. Though we know that this justification makes little sense because the Biden administration itself sought to end Title 42 policy nearly 1 full year ago. And DHS shortly after announced its own efforts to prepare for the end of the policy. So in this section, if you felt pressed for time to fully digest this rule and form a full comment, feel free to emphasize that and discuss that here. And additionally, if you have experience in administrative law, you can explain why a minimum time period is really crucial for stakeholders to weigh in. Great, thank you. So this next section will outline some concerns about our obligations under international asylum law. As Azadeh discussed, the US has adopted the requirements of the International Refugee Convention, and this protocol provides that any person arriving at the border has the right to seek asylum, regardless of their manner of entry. And again, as we've explained, this rule limits asylum eligibility based on the way that someone enters the country, their access to technology, or the number of appointments DHS decides to make available each day. And this directly contravenes with the principles and obligations that we've adopted. So here, if it interests you, you can choose to include your own concerns with the way that this rule undermines existing asylum law. And specifically, if you have experience representing people who were harmed by previous Trump-era transit bans, this would be a great place to include their experiences or anonymized client stories. Great. So our next section goes through some concerns regarding the CBP-1 app and making asylum contingent on access to technology. As we've discussed, this really increases reliance on the CBP1 app, and folks' eligibility for asylum depends directly on their ability to access and properly use a mobile phone app prior to arrival. And requiring people to access smartphones and reliable internet fails to account for gaps in technology, language differences, and economic disparities of people fleeing harm. And further, the rollout of the CBP1 app has already been shown to be extremely flawed. Users report frequent glitches, appointments fill before people can access the app, and racial disparities have been seen in the facial recognition technology required to access the app. And we know that as it exists, CBP1 is not available at every port of entry, and appointments have been extremely limited. Last week, Homeland Security Secretary Mayorkas noted that in February, approximately 740 asylum seekers were processed at the southern border every day under CBP1, which we know does not even come close to meeting the needs of asylum seekers. And under the limited number of appointments, families that come together as a unit are struggling to get appointments for each family member. And CBP and Border Patrol has begun to turn away families that can't secure an appointment for each member, wasting the appointments allocated for that day. So here, if you have concerns about this increase in dependence on technology and disparities that can happen with that, it'd be great to discuss them here. If you have concerns about racial biases that are common to facial recognition technology, you could discuss them here. And finally, if you have concerns about data privacy issues that could come from requiring asylum seekers to submit sensitive information, their biometrics, and their location data, you could discuss that here as well. And thank you to Azadeh for providing those 2 congressional letters that have been sent out that outline some more of these privacy, accessibility, and other concerns with CBP1. So on that note, I'll turn it back over to you.
Thank you, Isabella. So I'll keep breezing forward through these sections. The next one we have is about the parole pathways and how they are not a replacement for asylum access at the border. We've already discussed this quite a bit in the presentation earlier on. So feel free to reference those talking points and the text that we have here. But importantly, again, I'm focusing you in on the highlighted portion, which is where you have an opportunity to individualize and add more information. This is where you have an opportunity to basically share with the government how your prior clients would have been impacted if they had to look to parole programs as their main avenue for asylum protection, and why those kinds of programs would be too restrictive. So for example, if you've ever represented someone who was unable to secure a visa or was unable to secure not a visa, was unable to secure a passport, which is requisite for a parole program, or who lacked the financial means to buy a plane ticket to the United States. Those are the types of stories that you could share here in order to exemplify why, once more, this is not going to be a sufficient replacement. And of course, you know, it's valuable to remind the government that requiring asylum seekers to go to their government who may be persecuting them in order to get a passport is actually essentially ushering them to danger in many cases. So think about the ways in which, and unfortunately this is happening with Afghans these days, the Taliban is controlling the issuance of passports, and yet these passports are often a requirement for people to be able to safely leave Afghanistan. So there are many, many different examples of how this leaves people behind. The other thing, and getting to the next section, if you've ever had a client, essentially, if you've ever represented someone who was not Mexican or not Canadian, or unable to fly directly from their country of origin to the United States, then you should be able to speak to the fact that, when people transit through nations, that's not the same thing as them resettling in those nations or being able to seek protection in those nations. And there's many, many examples of how countries along the way in Latin America still have ways to go in order to have a robust asylum system that could actually even process people in a timely fashion. The prior administration under Trump tried to set up a safe third country agreement with Guatemala. And to give you an example, they sent about 1,000 people there, most of them women and children. And there was about one full-time asylum government official who could actually process those asylum applications. So for most people, those transfers to Guatemala from the US border ended up being a deportation order with a layover, as it's been called. So it's not an option for many women. It's not an option for LGBTQ people, for many Black asylum seekers, Indigenous asylum seekers to be able to seek protection along the road. They face significant discrimination, and there are many biases as well that have settled in terms of processing even within the Mexican asylum system. That makes it near impossible, for example, for Haitians to get protection there. And moving forward to the very clear due process concerns and access to counsel barriers that plague this rule as well. Again, remember that this rule is already building on a very, very broken and flawed system, which is expedited removal. Expedited removal is already a system that basically rushes people through, oftentimes while they're detained, while they're unrepresented, in a language that they do not speak or with poor interpretation, and in a system that they don't understand, right? So we have many horror stories, some of you might too, of these initial fear screenings that should be really low threshold and really benign, taking hours upon hours and resulting in people getting improperly denied. The consequences here can be incredibly devastating because being barred under expedited removal, as many of you know, results in a 5-year ban, and as well bars people from asylum eligibility moving forward, so they only have withholding or CAT protection at their disposal. And this rule, in the way in which it is building on expedited removal is concerning, because so much of the burden is upfront at this credible fear interview on the applicant to basically disprove that they shouldn't be subject to this presumptive bar. And that is a lot to ask of people. For many unrepresented people, for many detained people, there's very little difference between that and the categorical ban that we had under the Trump administration that resulted in injunctions under federal courts. So it's really incumbent on, frankly, attorneys to be able to spell that difference and show that, this calling it a presumption now when it used to be called a ban or a categorical bar is really meaningless for individuals, given the fact that there is no guarantee of counsel, that interpretation is subpar, and that people are going through these initial screenings in devastating circumstances while still bearing the scars of the harms that they fled. So we hope that this is helpful to you all. There is still a good amount of time for questions, and for any kind of individual questions that you all have about how you want to tackle the comment, or if you wanted to stick around and work on your comment with us, we are committing to stay until the end of the hour in order to be a resource for you all. So thank you all so much again for sticking around.
For those that have a question, feel free, we can unmute yourselves. Azadeh, there is one general question. Can you help us kind of really understand what it means to have a unique comment? There's a lot that could be added here. Do people need to fill in every section, a few sections? What can be a unique comment so that it's counted as an individual and not, pushed into one and counted with, multiple other ones?
That's a great question. Yeah. The Federal Register basically will group comments if they are substantively the same. What that really means is that, all of these yellow sections that you have in the draft are places that you should be trying to individualize and insert your personal experience with representing asylum seekers in. Otherwise, if we're just copying and pasting from the main text, then 3 of these comments could end up being 1. And the administration has to spend a lot less time actually reviewing these comments and taking them seriously. As I think Isabella had mentioned, we want to make sure that we are requiring them to review every one of these meaningful contributions and take seriously the impact that it's going to have on the stakeholder community. Oh, and one more thing on this point, you don't have to use every section here. We opted for having as many sections as we could think would be useful to you all. But you could literally pick one and run with it and just personalize that section, or you could use the whole draft. So it's totally up to you, but we thought that we would make as much accessible as possible.
If folks were just to choose 1 or 2, should they delete the other sections, or is it, advised to keep them in just to have the language there?
Yeah, it's a good idea to delete them in that case so that there's less duplication throughout the Federal Register. So yeah, that's a good point.
And again, just for the group, the template is available online. The link is in the chat. So if you haven't accessed it or you want to send it along to others and encourage their participation, please do share that link. We do have 1 whole week left.